Estate planning is often a topic that isn't something we like to think about, because what we need to think about is what happens when I'm gone. Estate planning in this day and age is not a simple one-size-fits-all approach. For most people, they think that their estate plan is all-encompassing within a will. Your will only covers the assets that are owned in your name. It doesn't cover assets that you own in superannuation, assets that are owned in a company or a trust. So when you're considering your estate planning, you need to also consider those assets that are owned outside of your own name. Once you've gone, you've got to make sure that the right people are in control of your assets so that they can implement your wishes. When considering companies, trusts and superannuation funds, you need to have a clear picture of who is going to be in control of these assets. The people who make the decisions in a trust are the trustees. Those people can be individuals or it could be a company. The beneficiaries are those people that receive the benefits of those trusts. There is another critical role in trust called the appointor or the principal, and their sole role and responsibility is to be able to remove and appoint a trustee. So when you pass away, you really need to consider who is going to be that appointor. It may be you and your spouse are jointly appointors. It may be that you're a sole appointor, and you need to then consider how that gets addressed in your will and within the trust deed of the trust. The assets that are within a company are owned by that company. They are not owned by the shareholders. Day to day, a company is managed and controlled by its directors. Those directors are appointed by the shareholders. So understanding who the shareholders of your company is and will be after you pass on is critical to understanding how your company is going to be controlled. Superannuation is a big one. Most people in Australia, their main assets are their home and their superannuation. And superannuation isn't covered by your will. Superannuation is governed by the terms of the superannuation deed. That deed, that superannuation fund deed, has a trustee appointed, and it's that trustee who makes the decisions on how those benefits are distributed upon your passing. Now, there's a specific law around who those benefits can be distributed to, but often it's something that's not considered, particularly when there's blended families and children over and under 18 years of age. To ensure that your superannuation goes to the right beneficiaries, you can provide a binding death nomination to the trustee, which will ensure that the trustee distributes those benefits in line with that direction. So as you can understand, estate planning is not just a simple one-size-fits-all. It's a lot more than a will. But fundamentally, it's about making sure that the right people are in control of your affairs and in control of your assets so that they can deliver on implementing your wishes after you've gone. At FWO Chartered Accountants, because we're across all of your affairs and all of your structures, we're in a unique position to work with your solicitors to ensure that your estate planning needs are specifically aligned.